moderator for the day, Elizabeth Auger-Gross. Elizabeth is a partner at White & Case in Paris, and she is part of the International Arbitration Group of White & Case. She advises clients in complex disputes in a number of sectors, with a focus on energy and construction disputes. Elizabeth has also significant experience representing acting for and against states. She is both civil law and common law qualified and is conducting arbitration in both English and French language. And lastly, Elizabeth teaches international arbitration at leading universities in France. Elizabeth, handing over to you.
Thank you very much, Elodie. And thank you, everyone who is joining us for this session on technology and innovation in arbitration. Now, while this subject in a different time would probably be discussed very differently, in the current times, this session takes as its starting point, evidently, the current pandemic of COVID-19 and the huge disruptions to travel that have caused a sea change in arbitration. Now, whether that sea change is permanent or temporary remains to be seen, but at least for the moment, it is certainly a sea change. And it has meant that the community of international arbitration practitioners has had to change the way they do a number of different things, and in particular in connection with the technology that they need to conduct their business. The responses to this have been swift and interesting, and we will be discussing them today. It used to be that discussions about technology were mostly about nice to haves, right? So we would discuss whether it made sense from a cost perspective to have technology, for example, that allowed participants in a hearing to see the transcript live as it was being taken, or for example, certain fancy software that allows the presentation and manipulation of evidence at a hearing. Or in a recent hearing that I had, the other side had this very nifty technology that allowed them to, whenever they read from the transcript during closing arguments, to have the witness's voice speak those words as it was during the testimony. Now, all of those are nice to haves, so no one would say that they are essential. And those used to be the discussions that we had. But now the discussions are very different. As hearings can't be put off indefinitely, the question is now the much more basic one of how we make them work remotely with lawyers, tribunal members, experts, clients, witnesses, etc., spread out over the globe. And of course, it's not only hearings, though that is the most pressing and important issue. We also have to deal, for example, with filings, which are more electronic than ever before. So to discuss these changes and how they're being dealt with from the perspectives of the different actors in international arbitration, we have with us today 4 distinguished speakers. We will hear first from Faith Macharya. Faith is a partner with Anjarwala and Khanna based in Kenya. Her practice includes domestic, regional, and international representation of parties before different courts, different arbitral tribunals, and in other fora. And her matters include complex commercial trade, employment, shareholder disputes, land disputes, and tax disputes. She will be addressing us from the perspective of counsel in international arbitration. We will then hear from Dr. Mohammed Abdul Wahab. He is the head of international arbitration and also the construction, oil and gas, and projects group at Zulfikar & Partners based in Egypt. He is a well-known and experienced international arbitrator with a wealth of knowledge to share with us from that perspective. He is also the chair of the Private International Law Department and professor of international arbitration at Cairo University, and he will be addressing us from the perspective of the Tribunal. We then have two representatives from African arbitration institutions. First, we will hear from Dr. Fidèle Massengo, who is the Secretary General of the Kigali International Arbitration Center. He also teaches international economic law and international competition law at Kigali Independent University, as well as international arbitration law at the Institute of Legal Practice and Development, a postgraduate institute that trains judges and other legal practitioners. And last but not least, we'll hear from Dipna Banu, who is the head of the MCCI Arbitration and Mediation Center, MARC, which is the Dispute Resolution Center of the Mauritius Chamber of Commerce and Industry. Before holding that position, Dipna worked in the litigation and international arbitration teams of Deckert, Durance and Garavi, Brown Rudnick, as well as the French Mauritian law firm PLCJ. And she also worked 2 years as counsel of LCIA MIAC. Now, before I turn it over to Faith, we have a poll that you can participate in today. The question is whether you have participated in a virtual hearing. I'm launching that now, and you will have a few minutes to participate. So please do submit your answer as soon as you can. With that, I hand it over to Faith for the first presentation. You'll also have the opportunity to ask questions in the Q&A tab while our speakers are speaking or afterwards during the question. Thank you. Faith.
Thank you, Elizabeth. Good afternoon, good morning, good evening, our participants. It's my pleasure to be here. I think from a counsel perspective, we've started to appreciate, if at all we've not already appreciated, the potentially catastrophic effect of COVID-19 on a core feature of the arbitral procedure, which is the in-person hearing or physical hearing, if you like. So that conducting all or part of a hearing virtually, it has become a daily reality for many of us, arbitrators and the witnesses, as we see the COVID pandemic continuing to disrupt our practice, the legal practice. Then we've seen most governments in the world, declaring lockdowns and extending such lockdowns. It's been usual. I mean, 2 days ago, that's on 26th of August, our president in Kenya extended the lockdown for a further period of 30 days. So we are seeing some countries that are gradually easing out of the lockdown and trying to find their way into what we'll call the new normal. And with this background, I think it's worth reflecting as counsel and as practitioners in this field, whether, and if so, how virtual hearings will replace physical hearings as a default mode for conducting oral hearings in the post-COVID world, if we'll have one. Obviously, if that being the case, it will involve the use of technology. And I think at that point, then it will become important for counsel to be innovative in the use of technology, to be innovative in the ways of hearings, and also coming up with ways to address the challenges that we have seen in technology by use of virtual hearing. I think just to help us think around these questions, I'd just like to share 3 points that I find to be useful. By all means, these are not exhaustive points, and views from the audience are welcome. So the points that I like to share with us, this is permissibility, and this is what I think at the top of the mind when I'm considering to use technology: permissibility, practicality of the technology, and eventually I will look at effectiveness quite fast. Now, when you're looking at permissibility as counsel, I want to confirm first the rules of the arbitration, whether they provide for virtual hearings. This is basically in order to know how to conduct the proceedings, and I think it's fairly accurate to say that national arbitration laws found in modern states, most of them have no specific prohibition against holding hearings through means of telephone calls or video conferencing. And also seen increasingly, and we can say maybe the standard practice, as we can see from the rules of most of the major arbitration institutions, they provide a broad discretionary powers to the arbitrators to determine, appropriate method of conducting hearings. And this includes the power to conduct the hearing virtually. So you can look at examples maybe at the Korean Commercial Arbitration Board. I know rules, I know they have such a provision, the Nairobi Center of International Arbitration Rules, and many others. Now, we may also want to look at the New York Convention, where most of us are touched, especially when it comes to enforcement of international awards in our local jurisdiction. I know the New York Convention provides, grounds to challenge awards for a violation of a party's right to equal treatment or its right to be heard. So far, I am not aware, and I'm happy, to take views from my fellow panelists and the audience of any reported cases where the imposition of video hearing instead of a physical hearing in and of itself was found to amount to a violation of these rights. Now, I'll go quickly to the second point, which is practicality. I think in the past, we've seen some reluctance to utilize video hearings. And maybe this could have been maybe to inaccessibility, for example, of video conferencing hardware, or even, prior bad experiences with unreliable connections. And I think coupled with the general inertia to change. But since then, we've quickly seen that technology has advanced and people have quickly adapted, especially during this COVID era. And now we can talk about an ample supply of low bandwidth internet conferencing solutions. Talk about Zoom, WebEx, Teams, Microsoft Teams, and many others. And it's fair to say that I think these platforms, they provide, reliable, high quality, video feeds that are accessible to our users. And I think just to help our users to go through it, I've also seen as counsel, there are enough video tutorials online, as well as we've seen protocols. We've seen checklists, we've seen guidelines on how to prepare for and conduct a virtual arbitration hearing. I've personally found the SOL protocol on video conferencing international arbitration quite helpful in this regard. It has given me some practical tips that I've been able to implement on virtual hearing. But just to say that for you to benefit from technology, you need to know how that technology will be used. And if you don't know that, then you may need to get help. And we are in a fortunate position because you've seen there's a lot of information online available that we can utilize of. Quickly looking at the last point, this is effectiveness. I think it's fair in my view to say that at this point, they are efficient, they are affordable, and generally reliable tools that have been developed to ensure that parties in attendance have their audio, visual access to each other, just like we're having now, as well as the use of digitized hearing bundles, live scripts, live transcripts, etc. Then as we know now with the virtual hearing, most exchanges of information today, it's digital, including international arbitration and other forms of dispute resolution. So there's an expectation by our clients that counsels will take reasonable measures to protect, like non-public exchanges of information. And these may include, taking measures like reasonable cybersecurity measures to safeguard digital information from unauthorized access disclosure. I think that's one of the key points that both players, the counsel, the parties, and the arbitral institutions, they have to work in hand to protect the confidentiality of information. As I finish, I think the question that therefore arises, and we are happy to hear views from our members, is when it comes to examining a witness, this being the main driver for physical hearings in the first place, is a virtual hearing as effective as a physical one? I'm aware there are arguments on both sides, but it would be interesting as well to get views from our audience. Thank you, Elizabeth.
Thank you very much, Faith. And if people want to answer Faith's last question on the effectiveness of hearing witnesses in virtual hearings versus in-person hearings, please do feel free to put your answers in the chat. We'll next hear from Mohammed Abdul Wahab. Mohammed.
Thank you very much, Elizabeth, and my esteemed colleagues. It's a pleasure to be here. I think it's a fair statement to say that much has been said and continues to be said regarding COVID-19 and virtual hearings. to the extent that people are either fed up or frustrated, not just by the events as they unfold in terms of the COVID-19 crisis, but also what new things could be added. And in the next 5 minutes or so, I will do my best to touch upon few issues that I think are takeaways, in hope that during the Q&A we will have sufficient time to discuss further. So my intention is to briefly give an overview of the status quo, and being mindful of the status quo as being things as they are, I will say the following. In the past, we have had all hearings physically in person, with emphasis on physically, of course, because my view of in person, whether virtual or physically, is the same. You could be appearing in person as we are virtually, as you could be appearing physically. So I think the distinguishing element is the physical presence. So the past, everything was done physically. Then gradually, the practice has distinguished procedural type of hearings from hearings on the merits. And I think there is a degree of consensus in international arbitration that for procedural matters that do not call for a physical gathering into a room have been done via teleconference or video conference, and this has become more or less the default system, to the extent that it would take a reasoned application to deviate from this practice. Then COVID-19 came about, and we were all either in lockdown or subject to curfews or to sort of physical distancing in a way. And so people had to continue with their business, their disputes and arbitration. And so virtual hearings were the only option for a period of time during the COVID-19 for hearings on the merits. And that, I think, is the transformative element of COVID-19. Because what has happened is that people have experienced, for good or for worse, the possibility that hearings on the merits could also be done virtually, even if people felt a discomfort, a disliking, or have embraced this and found it to be a game changer. So this is the present. And I think for the future, it would not be correct to say that the current present is an interim flash. I think what will happen is that this will continue to be the case, and we will see that virtual hearings on the merits will more or less be a default option with the physical hearings that may take place in the future. The thing is, there could be shifting in the burden of proof. Instead of one party requiring a physical hearing without making any reasons, I think now there will need to be some compelling reasons to suggest why it would not be more efficient and practical and cost effective to proceed virtually compared to physically. And that brings me to the structured approach that I have proposed in a pandemic that I've provided, but briefly so. I think the structured approach is founded on two things: the parties' agreement or the parties' disagreement. My view is that if the parties agree to hold a virtual hearing, then so be it. And if they agree not to hold a virtual hearing, also the tribunal should not compel them to hold a virtual hearing because the parties wish to have a physical hearing. Now, if the parties disagree, which is the overwhelming majority of situations that require intervention from the tribunal, we have to look at the applicable procedural rules, the law, and I think Faith has mentioned the idea of whether this raises due process concerns and whether courts will take the position of setting aside. And even though there is no recorded precedent on this, bearing in mind that the courts themselves have suffered the ramifications of COVID-19 and have themselves went online with their hearings, it would be very difficult to foresee a situation where a virtual element would be the exclusive base for setting aside an award or declining its enforcement. But I'm with emphasis on exclusive as such. And then I think the other element that requires a lot of reflection, in addition to the rules and the law, are the case specificities. And when I talk about the case specificities, it is not simply a function of quantitative assessment of the number of witnesses, experts, or whatever. I think it's more of a qualitative analysis of all the elements of the case, the parties' counsel, accessibility to reliable technology, the ability to be efficient in conducting the hearings virtually. All these elements will be analyzed by the tribunal, and again, subject to reasoned applications or arguments for or against in a way. But the game changer, as I mentioned, is that people have seen that virtual hearings are working to a large extent, and you can do it online. And of course, from a tribunal's perspective, and having done it both as counsel and as a tribunal member in terms of virtual hearings, tribunals welcome virtual hearings. They're efficient, they're fine, you don't have to leave and travel across the globe. You can do it efficiently, and it invites counsel to be very efficient in terms of use of time. Instead of spending days, hours pleading arguments, you need to go ahead with your clever arguments, which brings about more efficiency and cost effectiveness. So for a tribunal, I am yet to hear from an arbitrator that virtual hearings are not fine. But from counsel perspective, I have seen situations where counsel are out of their comfort zone. It's not the way that we have been doing things. The team may not be in the same place, and they are pleading the case. So it's not quite yet the ideal situation. Not because of technology, it's because people are not yet used to it. And I think it's fair to recall the statement that once a new technology rolls over you, if you're not part of the steamroller, you're part of the road. So I think people need to embrace the fact that there are technologies, and we need to measure the efficiency of virtual hearings or their, what can I say, altruistic approach to virtual hearings in a way, not on the basis of the existing technology, but what would be the technology, not in few years, in few months' time. In 1999, I wrote an article that was published in the Oxford Journal of Technology, where I said there will be a time where there will be hearings through holographic visual projections. And everyone was laughing at the time, saying you're affected by Star Trek and science fiction. But I think the reality is now here. We see holographic visual projections in airports, in applications. It is going to be the situation where you will 3D or even 4D or whatever dimensional presence of people in hearings, and it could sometimes be difficult to distinguish the physical from the virtual holographic projection of people. So I think we need to adapt to this and see how best tailor the process. The takeaway as well is that we see dispute providers offering new tools, new technologies, new platforms, and people have to up their game. And I think one of the defining elements, and it's again one of my takeaways from the perspective of an arbitral tribunal, the rise of tech-savvy arbitrators. I think those who aspire to do arbitrations as arbitrators will need not only to familiarize themselves with an appearance online, but to master the tools available out there, because the parties will soon be looking to integrate in their choices the tech-savvy element for arbitrators. Thank you, Elizabeth.
Thank you very much, Mohammed. I think that it's certainly the case that this has been a huge trial that never would have happened beforehand. If you had said to counsel a year ago, let's take this option of having a witness and expert hearing virtually just because we can, or as a cost-saving measure, I think you would have been laughed out of the room. And after this experience, whatever the outcome, nobody will be laughing anymore. And that is certainly a huge change in the way we do business. We will now hear from Dr. Fidel Massengo. Fidel, I hand it over to you.
Thanks a lot. I'm really pleased also to be part of this panel this afternoon. As Professor Mohammed has said, it seems I don't have new things to add on what have been said, because we share the same issues, and we are facing the same reality. I'm going just to give my perspective of an arbitral institution in Africa, and I will focus on mainly three things. Number one, I will just talk about logistic issues we are having as a center. And actually, when I talk about arbitral institution perspective, I'm just talking about the abilities for an African arbitration center to engage with parties in a virtual hearing proceedings. And as you know, technology is not very advanced in Africa as it is in Europe, and infrastructure-based tools are not also available and at the point as it is in many other continents. But they are very good progress. Just I'm going to give you some of the challenges we are having as a center. So on logistic issues, let me just talk four things. The first thing is the issue of the infrastructure itself, what we have as infrastructure. All arbitral institutions in Africa don't have proper infrastructure, such as video conferencing and high-speed internet. But for our center, of course, we've been using this for the last 4 years. But I know it's not an easy issue for many centers that were like caught in the urgency of having those infrastructure ready in short time like this one we've seen. But for us, we were already prepared for it for during the last 4 years. So video conferencing, high speed internet needed. Number two is also the system of technology to use. Here I'm talking about either having a software management system that was already conceived before COVID-19, or a choice of an appropriate online platform such as WebEx Teams, such as Zoom and many other platforms. For our center, we didn't have the case management software system that is really well developed. That's now that we are finalizing the procurement of it. But we used to allow online case filing and online exchange of document, but it was not yet a system that was really complete. So a complete system is being now developed, and we are expecting to get it ready by the end of this year. Another aspect on infrastructure, it's now manage the technical support needed. You engage in virtual hearing, and many arbitrators are not well trained in IT. That some of them are old generation judges, arbitrators. They can't easily cope with the technology. So we had to hire a technical support staff to manage, especially complex cases, whereby you have like witnesses, you have like expert, you have to manage cancellation, postponement, and the organization of virtual hearing proceeding itself. So this also is another challenge in infrastructure. So you have to make sure that somebody is there to help them, to make sure that he knows or she knows who speaks, who stops, if they are like breakout sessions, how to manage all those aspects. There is also an issue of time zone. So infrastructure is good, but remember, you will have arbitrators that will be at all the part of the world. Some will be available when it's evening here or morning here. So it's not easy also to manage those aspects. Number two aspects, procedural, law, and due process. On that one, I will not take long. We were not really well prepared on this. For like our context, we can only proceed on virtual hearing when two parties agree. If the tribunal decide on to conduct a virtual hearing without the agreement of the consent of the other party, one party, the award can be subject to challenge. So I'm saying this because we are like encouraging arbitrators to seek the consent of both parties and sign this in their terms of reference. Lastly, is the issue of privacy and the cyber security. This is also an aspect that has to be considered by many arbitration centers. Here I'm talking about issue for the tribunal to verify the identification of participant and make sure that no unauthorized person is hiding behind the screen, because you can have like witnesses and other people behind them. So it's an issue, and many arbitrators will tell us that, we know that we have a virtual hearing. Make sure that parties come to your center, and we make sure that at least you know who enters in the room, who is on the screen, and to make sure that there's nobody behind the screen. So for cases where parties cannot come at our center because, for example, one party is from abroad, we cooperate with other centers or courts to make sure that we have people to monitor who is going there, so their identity. I think it's what I can say for now, and I'm willing to come back for questions, if any. Thanks a lot.
Thank you very much, Fidel. Dipna, I'll hand it right over to you.
Thank you, Elizabeth. Good afternoon, everyone. Good morning or good evening, wherever you are. And as my other speaker, it's just a pleasure to be with you all today. And I would like to thank AAP for organizing this amazing session, thanks to technology. So just like my other speakers pointed out, COVID definitely disrupted the way we used to do business, especially as an arbitral institution, because by mid-March this year, we already found parties that were already asking the arbitral tribunals and Mark, the center here, the Secretariat, for extensions of deadlines, for revision of the procedural calendar and orders, and even asked for the postponement of hearings. So during that period, some parties even asked for a cooling off period in order to try and settle their dispute, because they had new priorities other than going through a dispute at the time. So in Mauritius, for example, nationwide lockdown and curfew were both declared by the end of March 2020. So we had to put in place a contingency plan at the MARC Secretariat regarding our filings of requests, the submissions of documents, the amendments of procedural orders and hearings. And this pandemic clearly showed the limits of any arbitration institutions. And this showed as well the ways to improve and what should be done in order to cater for this kind of a situation. And we really had to reassure all our stakeholders involved in ongoing cases, but also in future ones. So we had to start working with a service provider for online dispute resolution services, mainly for its virtual hearing platform. We at this time didn't find any service provider that was based in Africa, so we had to team up with a company that is based in India. So hopefully they have been able to offer all the tools that we needed in order to offer to our users and our stakeholders tools and means to go through their hearings, to send safely their documents and any document that should be submitted. And this service provider based in India offered all the cyber protocols and tools and the security in order to safeguard the confidentiality of the proceedings as well as the privacy of the parties to the arbitration. But even if it was a service provider that was based in India, it was not too costly compared to other service providers based in Europe or in the USA, for example. We still wanted to go through a platform or a service provider that would be based in Africa. So this is why we are currently trying to implement our own virtual platform here at MARC with our online filing system, and with our virtual hearing platform. So we are currently teaming up with an IT consultant who's African and who's also a lawyer, so he understands better our requirements and our needs. And as soon as this new proposal is approved by our advisory board, we'll see whether we'll have to add an addendum to our rules or we'll modify our practice notes in order to cater for electronic filings, submissions of documents and virtual hearings. But we definitely had, to adjust our services and see how we could provide our help and assistance to parties during this difficult period. But at the same time, it was a great experience to see what should be improved, and in order to, to propose what other institutions based in Europe or in Asia are already offering, and to somehow, set up the stage for Africa and lead the way and try to align ourselves with other African institutions by providing the same level of high services.
Thank you, Dipna. So you mentioned the difficulty in finding a service provider, in particular one on the African continent. Once you found the service provider in India, and as a general matter, what are the challenges that you have experienced, have gotten through in terms of implementing those systems?
Well, the most important challenge was the technology and the security system that were required. So we had to find a service provider that would, meet the requirements, that would already be in the business, be familiar with the needs of an arbitration institution. And another issue that we're currently facing here in Africa, it's the cost. Even if we are teaming up with an African service provider, you still need to buy softwares, platforms that are owned by foreign companies, and the costs are extremely high, especially for an African center. And at the same time, when you want to offer these kinds of services, you ask yourself as an institution whether this investment is really worth it, given that our services and facilities are currently, unfortunately, underutilized by the arbitration community in Mauritius and in the region. So we really want to offer this kind of services, but if at the end of the day nobody uses them, is it really worth it?
Okay. And so then, given this underutilization and the high costs involved, is there the possibility, are you doing this, of using this technology for any other purposes?
Well, we are trying to promote these virtual platforms that we are currently implementing here at MARC. And we are seeing other bodies, even courts, that are using our virtual services. We have the Redundancy Board, that is a public body that focuses on labor disputes in Mauritius, that is willing to use our virtual platform and our facilities. We already offer, hearings before the Privy Council. So it really shows that an arbitration institution offers advanced methods of dealing, with this kind of situation through technology and virtual tools. So we can see that we are somehow acting as a pioneer in the legal field here in this jurisdiction by indicating to state courts that those methods are reliable and that they can be safely used in the future.
Thank you, Dipna. That's really interesting to hear about the crossover, and maybe that will, I don't know, inspire other centers to also look at using this sort of crossover. Fidel, coming back to you for a moment, and staying with the institutions for a moment, how do you think the new technology of virtual hearings is going to change, even transform your institution, and what investment and legal reforms are needed to implement the new technology? I think we may have a sound issue, Fidel. Are you on mute?
Yeah, I'm saying that we are expecting a complete change, 100% change. Why I'm saying this? In Rwanda, for the last 4 years, courts have been using virtual hearing, online hearing for, I can say, now it's like up to 80% of cases. They have what we call integrated electronic case management system, which is used now by all court stakeholders, including lawyers, parties. So you understand that this is a change that the government has opted for this. it has invested in this. So the arbitral institution cannot stay behind. We don't have any excuse. We just had that video conferencing system, but we didn't have the proper case management system that we are now acquiring to make sure that we are in line with the policy in the country. As I'm saying also, we need to do this for several reasons. Reason number one, it's easier to do virtual hearing than doing a physical hearing. It is the cost because you know, when you have like international case where by an arbitrator needs to travel from you know, any part of the world to Kigali, so you understand that you reduce the cost for Paris. You don't have like airfare costs, you don't have like hotel costs. So that's number one. Number two, it's easy in access because people access it easily. You don't need to print hard copy to come. You don't need to send a document via DHL, very expensive. You know, it's easy now. People are, you know, enjoying using technology, and it's a good thing because our court system is also used to it. Even our, you know, evidence law allows it. You don't need to print document. That's a good thing. It's also facilitate the access to court service. We can use good arbitrators from around the world, whereby in physical hearing, you not only have those who are living from the countries where it's not expensive to travel to Rwanda or where, but you can, you know, who are available. But when you go on virtual hearing, many arbitrators are available because they just they can work on their time, you know, agenda and accommodate the time for an audience in Rwanda. I mean, a hearing in Rwanda. So there are reforms to do, as of course, infrastructure wise, as I told you, we are very advanced because we are at like 80%, and we are about to put also that case management system. And we also, I can say that we have also to train some of the arbitrators who are of the old class, old school, because they are not very used, you know, to IT system. That's what I can say now. So, but the move is there, and I can say that we have to. It's no longer an option. It's a must. Yeah.
Thank you, Fidel. Moving to a different topic, which is confidentiality in virtual hearings. So we know that confidentiality, of course, is not the same in all arbitrations. There are different levels of confidentiality that are required, whether it comes from the contract, from the arbitral institution's rules, or sometimes from national law. But where confidentiality is an issue, how do we maintain confidentiality in virtual hearings? And I'll ask this of you, Faith.
Thanks, Elizabeth.
How we deal with confidentiality? I told you that I can't hear you very well.
I was actually asking this of Faith, but if you also have
that issue of
I can come back to you.
Hello?
Thank you, Elizabeth. As I mentioned earlier, we are seeing
frozen. I'm frozen.
Elizabeth, should I proceed?
Yes, please do.
Thank you so much. As I mentioned earlier at the start of my opening statement, is that we're seeing most exchanges of information today digital. And of course, this has not left out international arbitration practice and other forms of dispute resolution. Now, there's some practical tips which I have implemented. And of course, I've got a lot of guidance from the SOL protocol on video conferencing hearings. So some of the things that I've done, by all means, this list is not exhaustive. parties are at liberty to think more and, of course, to add to that. And I know Mohammed will also be chipping in. So I have asked that we maintain a pre-approved list of authorized attendees and their emails, and this is basically to keep off, hackers, for example. We have adopted, waiting rooms, so that access can only be granted to authorized person, and these persons identified prior to the hearing of the matter. Checking to ensure that all current updates, security patches have been installed before using the platform. And you can think about maybe by IP to IP encryption. There's so many, technology alternatives out there that can help us do this. Then I think the other thing is parties may consider coming up with a procedural order detailing a cyber protocol, which basically can set out the manner in which virtual hearing will be conducted, including safety and privacy considerations. I'm actually aware of draft cybersecurity protocol for international arbitration by, I think it was the International Council for International Arbitration, the New York State Bar Association, and International Institute for Dispute Resolution. It actually has very good guidelines and tips for parties to come up with cyber protocol agreement if they so wish. Then the other thing is we have agreed on whether we need the proceedings to be recorded, and if so, in which manner. Do we need the consent of the arbitrator to record the proceedings? If the proceedings are recorded, within which timeframes, for example, should these recorded proceedings be shared with counsel, be shared with the arbitrator? Then we've also, seen cases where people limit the screen sharing to the host, and they just disable file transferring unless necessary for the hearing. And also something about the chat function. I prefer to use the chat function on information that I'm comfortable with the written information going on record, unless, of course, someone can confirm that that the chat is encrypted and the restrictions on saving and downloading and recorded are enabled. And this is because there are actually other platforms that create chat transcripts as a default setting. So you just need to be a bit careful on that. You also need to inform your client, I think, in good time, not to use the chat function during the hearing. And maybe what I've done, I've set up a different, confidential way to communicate to my client during the hearing. Parties can think about maybe executing undertakings, where necessary, by all participants in the arbitration, indicating that they shall not disclose any information pertaining to their arbitration. And maybe the final tools to share is that you can think about sharing documents through secured virtual data rooms or other platforms that parties shall agree upon, and you only grant access to access details to the authorized personnel. Thanks, Elizabeth.
Thank you, Faith. Mohammed, I wanted to ask if you have anything to add to what Faith just said about confidentiality from a tribunal perspective.
Yes, briefly, I agree with what Faith has mentioned. Let me just say the following. We should not confuse confidentiality with privacy or cybersecurity. I think they are distinct concepts. What I think we're discussing here is a matter of cybersecurity and ensuring the privacy of the proceedings as such. Because if we talk about confidentiality of the arbitration, the award and stuff, this is a whole important debate about whether confidentiality is a default or a required or agreed situation. But taking things online, I think for every technology out there, there is a possibility, unfortunately, to hack it and a possibility to patch it. And this will keep going. Same in the physical world. I think we have the comfort when you see everyone in the room, then you realize that things are secure, but not necessarily so, because people could also be having access through satellites, through seeing what you're actually doing without you noticing. So I don't think that taking things online does exacerbate or worsen the situation much, to the extent that you have the adequate protective tools in terms of cybersecurity, which I must say, in all candid opinion, is a huge issue for Africa and other parts of the developing world, where we have a minimal number of secure servers, minimal measures to be taken to counter illicit access to information. But in any event, this is not just a function of virtual hearings. It has been quite a while in traditional arbitrations where we've seen illegal access to documentation, hacking, even for systems, even in a physical, purely physical arbitration. So I think people just now need to invest more in cybersecurity measures to ensure that they require protection needed in this respect.
That makes sense. And staying with you, Mohammed, how do you prepare for a hearing as an arbitrator? And in particular, does that preparation change when you are dealing with a virtual hearing as opposed to a physical in-person hearing?
Thank you very much, Elizabeth. And again, briefly, I don't want to take much of the time because we have very interesting questions that I'm really interested to address. To me, it does not make a difference in terms of the preparation. And I'll tell you why. Because I've taken the decision about 5 years ago to go fully electronic in terms of when I sit as an arbitrator documentation. So instead of dragging suitcases that include case files or having them couriered there and to the hearing venue and stuff like that, I have everything electronically available. It's much easier to navigate, more environmental friendly, more cost effective, more efficient. Even when you sit with colleagues on tribunals, it is much quicker for you to navigate through the electronic file than a physical file. So it saves time. So that's why when COVID hit, it was not a novel concept for me, and it does help a lot. I think in terms of the infrastructure preparation, it's different, because now if you're taking the hearing virtually, you need to ensure you have, people have provided excellent insights on having large screens, alternative internet connection. But I think what really matters is preparing for your case substantively. And to me, it doesn't matter going virtually or physically.
Thank you. I have to say that the pandemic has caused a change for me in the way I prepare as counsel for a hearing. I had resisted for years reading documents from the other side on screen, because of course I had my old school habits of marking them up, and then we had to do it during the pandemic, and in fact it's really not so bad. And I imagine that there are quite a number of practitioners who've had the same experience as I have, and that is good news for the planet and the enormous amount of paper that arbitration practitioners use, which is really just completely unseemly. Fidel,
you are just pushed out of your comfort zone and you survived well.
I did.
It's a typical thing for humans. We do things in a certain way and we realize, oh, that's the best. No, it's simply the comfort zone.
Yeah, no, absolutely. And it really is just, in fact, it was just habit, because it works just as well. Fidel, I'm going to turn back to you for a question about the selection and appointment of arbitrators. Do you think that the use of virtual hearings is going to have some effect? And in particular, what effect is it going to have on diversity? I think you mentioned when you spoke earlier the availability of arbitrators to participate, for example, in a hearing in Rwanda. So that might make us think that actually it will have the opposite effect, because there'll be no need to turn to people closer to home. But what effect do you think that virtual hearings will have on who is chosen, and in particular on questions of diversity?
Yeah, thanks a lot. I think, as I've said it briefly, virtual hearing has many benefits. There are also some challenges, as my colleagues and myself have said it, but there are many benefits, especially when it comes to the selection of the arbitrator. For example, for now, when you have like a case with a small amount of dispute, amount of money in dispute, when you talk to party to have international arbitrator, from like Europe, from like US, from like Asia, they will tell you, you know, see, there is the cost. We have to pay the cost for the arbitrator to come. We have to pay the hotel. All this now with the virtual hearing is not an issue, because they can now select an arbitrator who is abroad, and the arbitrator will sit as if he's in the country. That's a good thing. Cost-wise, virtual hearing will, is helping us to access good arbitrators of all corners of the world. That's on the cost. Another aspect is the issue of language as well. You know, when you have to fly an arbitrator to come from like a francophone country, let me say West Africa, there are places in West Africa where you don't have direct flight to Kigali. You have to do like many flights before reaching here. So if you propose an arbitrator from West Africa or France, they will tell you, you know, again, the issue of cost. And you will only get an arbitrator from maybe the neighboring country of in Rwanda, who is not the best at that language. Think about some complicated language like Arabic, like Portuguese. You can, you know, have now plenty, you know, opportunities of choices, because you can use an arbitrator who is far. When it comes also to gender diversity, there are places where you have very good women arbitrators that we do have probably in the region. So that aspect also is a good aspect. I'm just saying that based on the cost, based on the availability, based on the flexibility, because people will be flexible, I can say that we can expect a positive impact, especially on this aspect. Yeah, I don't see any negative impact. Of course, competition will be higher, and best arbitrators will be selected in, you know, to sit as arbitrators in many countries. But at least the positive impact is well expected on this aspect. Thanks a lot.
Good. That's
If I
good to
may,
hear.
Elizabeth?
Sure, please do, Dipna.
In terms of diversity, I would say that it would increase the pool of arbitrators, because you will have young arbitrators that are more tech savvy, you know, that would be more often appointed, because this is probably a requirement that arbitration institution will have to add to their statement of independence. Are you tech savvy? Are you comfortable using virtual tools or not? So obviously the younger generation is more comfortable using this kind of tools and methods. So this will definitely increase the pool of arbitrators. So it's a good thing.
That's also a good point. One more question from me before we turn to the questions from the audience, and we have lots of good questions. So maybe we can try to be relatively brief on this one. And the question is the future of virtual hearings. So are we going to go back to the status quo or something relatively close to it after the pandemic, or will we instead stay with virtual hearings as the norm, or will it be somewhere in the middle? And I'll ask Faith and Mohammed for their very brief response on this question. Faith first, please.
Thank you, Elizabeth. A challenging question. But I think the probable answer, in my view, is neither. I think we are likely to see some of us reverting to our old ways to some degree, while adopting the virtual hearing format in a manner that best fits our needs. I think it may be to be difficult to argue that virtual hearings can fully, and I think the emphasis is fully, replicate the nuanced, the instantaneous, so to speak, interaction between tribunal, counsel, and witnesses, which physical hearings they do offer. I mean, observing a person's overall demeanor, their surroundings, the real-time reactions of other participants in the room, it yields such useful information to me. And I mean about the virtual hearings, there have been concerns such as, witnesses reading off notes or being coached off screen during cross-examination. You know, at times arbitrators and witnesses, they're not looking at the correct, you know, page of a key document at the right time because of maybe technological differences. I mean, these are just some of the challenges that we faced with virtual hearings. And I know there have been proactive steps through, you know, arbitration centers, through protocols to address these challenges. On the other hand, there are success stories about virtual hearings. Mohammed highlighted some of the success stories that we have for virtual hearings. And now we have gained experience during the COVID hearing, you know, to conduct hearings virtually. And I think the success stories, coupled with this experience, in my view, it will encourage more frequent and proactive deployment of virtual format, even if maybe it will pertain to part of the hearing of some of the participants. Mohammed talked about, you know, reduced expenses, the time spent flying from one continent to the other, the environmental damage, if I may say, for, you know, the long haul air travel. But in a nutshell, I'll say it will be a waste of time for me, a waste not just to maximize the benefits associated with virtual hearings, as long as it is ensured that the essential elements of a fair hearing are observed. And going forward, I think we are likely to see both the physical and the virtual formats. They all have their pros and cons, and it will be upon the parties to find the right balance for each case, in my view. Thanks, Elizabeth.
Thank you very much, Faith. There are certainly very interesting issues raised here, and I think one that I'm finding intriguing at the moment is just the way witnesses feel being cross-examined when there's a screen between them and the questioner and them and the tribunal. And I think, you know, whether this is a good thing or not, they don't feel the pressure in the same way that they do when they're sitting in the middle of a room that has seats all around them and all eyes are on them and they can see the eyes on them. So I think that's something to be taken into account. Mohammed, anything to add to what Faith said?
Well, Elizabeth, again, I fully agree with you and Faith, and I think the emphasis on the point that you mentioned, which I intended to mention, is that witnesses definitely do not feel the pressure as before. They're sitting within the vicinity of the surroundings and parameters with their familiar, the comfort of their homes, definitely. But I think you would agree, and I think this is an area, COVID-19, speaking to many colleagues from both the civil and common law world, I think the civil law traditional practitioners are quite happy. They say, see, we told you from the beginning, what are you talking about with witness evidence? And I think, in all fairness, if you as well read the seminal piece by Toby Landau on witness testimony and whether it's overrated or not, and whether witnesses are saying the truth or whatever, it is not something that I present to you as a skepticism, not at all. But I think the following, I think for the future, you will have hybrid forms, definitely. And I did mention that as early as March. In huge arbitrations where you have opening pleadings, oral pleadings over a couple of days or so, these will be done online. There are no witnesses to cross-examine or so, and it will save time and cost. Witnesses of fact, specifically, this is something interesting. I notice people have difficulty with witnesses of fact online. They accept to cross-examine expert witnesses online, but witnesses of fact seem to have the appeal of requiring their physical presence within the same vicinity or room of the cross-examiner. And I can understand this is the traditional way of doing it, but there is an additional layer. When you are in the virtual environment, you're not going to spend as much time with the witness of fact as you could do in a physical environment. You would spend lesser time, you choose the lines of cross-examination, and sometimes, because of the time span and the hours during which people are sitting online, you can even make a judgment call about who to cross-examine, which is not ideal for counsel who may want to use, you know, all the arsenal available to him or her in terms of cross-examining the witnesses. So it's quite interesting. That said, I invite all participants to consider reviewing two things. First of all, the New York Dispute Resolution Journal has issued a just few days ago an issue, special issue dedicated to viral changes in ADR during the pandemic. And they address the issues of remote or virtual hearings, specifically, including as well witnesses. And the other thing, Kluwer, and that's not a PR thing, no, but Kluwer is publishing a book on international arbitration and COVID-19, which includes pieces on witness testimony. Of course, this book is I think it's very interesting because it addresses the aspects of COVID-19 on international arbitration and sector-specific experience within the aviation, telecommunications, construction, energy, and how things have changed. It is edited by Maxi Scheller, Nusha Basiri, and I'm just joining them as editor. So I think it's interesting to watch out for these two things and have a look at them. Thank you.
Thank you, Mohammed. I think that's super interesting and matches my own experience on the different reactions of civil and common law practitioners to the whole witness testimony question and whether it's really a truth-telling exercise. And then, of course, the civil law practitioners think that they all lie anyway. So what does it matter if you have a screen between you and the witness? I'm going to turn to the questions from the audience now, and I'm going to start with an interesting question posed by Duncan Bagshaw, who asks whether if hearings are held remotely with the facility to record the feed, should arbitrators review the video recording of key parts of witnesses' evidence before making their findings? And if not, why not? And I guess this is probably most appropriately posed to you, Mohammed, as you're speaking from the tribunal's perspective.
You see, I think that if the parties have not agreed to disregard reviewing these feed parts, I think there is no reason not to have a look at it, and it's useful. And believe it or not, even in hearings and when looking at the videos, people and arbitrators, speaking to at least a couple of them, found that they can see the witness much better compared to a physical hearing in presence. They can see, you know, the emotions, the body language stuff. But of course, the difficulty is that you can't distinguish the fact that the body language, is it simply a discomfort because you are online or being recorded, or is it simply because you're not saying the truth? I mean, it's a fine line you have to consider, or not sure about what you're saying. So I agree with Duncan. I mean, why should they not do that unless the parties have considered this in a protocol and says, you know, certain parts are omitted one way or the other?
Yep, makes sense. We have a question from Aisha Abdallah, who asks, where is the venue when you have a virtual hearing, which is an interesting question. Perhaps I can ask this to you, Dipna. Have you come across this issue?
Well, not yet. We haven't faced this specific issue yet, but it is an excellent question, because when you say that the venue should take place in Mauritius, for instance, and that you are using an institution that is located in Mauritius, but through a virtual platform that is based in India, where is your venue in that case, you see? So this is definitely something that we have to, you know, confirm with the parties when this situation will occur, but this is definitely an excellent question. So probably when we are drafting our arbitration clause, this is something we should, you know, include as well, and put in detail whether you are agreeing on a particular venue to take place, either if your hearings are taking place virtually or in person. So this is an excellent point, and thank you, Asha, for raising this.
May I chime in to agree with Dipna? But it was one of the questions that I wrote a written answer of a number of lines, and suddenly when I was about to click send, it disappeared. So I was quite frustrated. So let me say the following, and that was my immediate response to Aisha. Did you mean venue as in territorial venue, or did you mean the seat, which is a legal concept? I think we need to distinguish both, and all arbitration laws do distinguish, and rules distinguish between the venue and the seat. If she means the seat, then there is no issue at all. Even online arbitration rules, the seat is a legal fiction that we created for the courts of primary jurisdiction, and that is no issue and has no territorial connotation or physical. But if you mean the venue, I agree with Dipna, And we have faced this in online dispute resolution, strictly online, not just virtual hearings or remote hearings. And there are several options here. The parties can agree, and definitely should do so, on the venue, even when you go virtually. If they don't, then there are the view is it is the place of the where the platform is located of the institution that you are using or the provider you are using. The other approach, which has gained some support in certain parts of the US, is that you look at the login, where the servers are located within the login. So we all log in from different parts of the world, but the point of entry is somewhere where the servers are located, and this could be then the venue. Now, the issue with that final approach is that people may not be familiar technically with where these servers are located, so it was never intended to be the venue. So I would suggest that it's the parties either agree in their protocol, or then it would be the platform of the service provider whom they have chosen to use their services in a way. Thank you.
Elizabeth, just to add to what Dipna and Mohammed are saying very quickly, and I think this is a more practical question. I think now we need to think of how we draft our dispute resolution mechanism. A change has happened, a change has occurred, so it's no longer the way it was. So our commercial lawyers who draft the dispute resolution mechanism in the dispute resolution clauses, they have to think about this question and these issues that Mohammed has raised. The seat, it's not so difficult, but when you need to think about the locations, you need to think about if you're going to a service provider in India or in whatever jurisdiction you're thinking about, what are the possible consequences of the choices of venue, if you want to specify in the contract, or the seat, so to speak. We have to start thinking that proactively, not leaving such questions to when the dispute arises much later.
Okay, thank you. I think that we just have a couple of minutes. Maybe I'll just ask one other question. And I seem to have lost it. Let me just get back to it. Sorry, I'm having trouble with this, but I think actually we're out of time anyways. We're supposed to stop in 1 minute. So I will thank all of the participants, both our speakers and those who have been sending in questions. I'm sorry we didn't get to all of your questions, but the ones we did get to were very helpful, and I understand that some have been answered directly in the chat. And so thank you to everyone who participated today.